PET, the petition of Otter Creek Solar LLC for relief from both the standard offer contract commissioning milestone and waiver of the certificate of public good milestone for the Otter Creek 1 project. I want to note for the record that we are conducting today's oral argument by video conference. As a result, we will need to observe a few ground rules to make sure we go about this effectively. First, we will start out by taking appearances. I'll ask for an appearance from each party, and when I call that party's name, the representative here today on that party's behalf should state their appearance. Otter Creek Solar.
Good morning, Mr. Chairman. Tom Melone for Otter Creek Solar.
Welcome, Mr. Melone. And for the Department of Public Service?
Daniel Burke for the Department of Public Service.
Oh, welcome, Mr. Burke. I have some construction work going on outside my window here, and so I'm going to probably, once I get done with this introduction, go on mute, and will only turn on my microphone if I have a question to ask at some point in the proceeding. Are there any members of the public in attendance or listening by phone? Now to some ground rules. First, no talking over each other. Second, please wait to be acknowledged before speaking. Third, please state your name each time you begin to speak so the court reporter knows who is talking. Fourth, if you want to be recognized to speak, please wait a few seconds after someone else speaks to be sure they are done. Then ask to be recognized. You could raise your hand, I can see you and can recognize you in that way. Keep in mind that I'll be recognizing people to speak in order as we progress through today's hearing, and we'll try to provide everyone with appropriate opportunities to both speak and respond. The intent is to minimize the need for people to have to affirmatively ask to be recognized. Before we move to the parties' arguments, I want to acknowledge that on June 11th, Otter Creek filed a motion in 7 different cases, 5 of which are pending before the Commission and 2 of which are on appeal before the Vermont Supreme Court. This was one of those cases. We will not be discussing that motion during today's argument. Otter Creek did not request that this argument be canceled, so we're proceeding today with the arguments addressing the merits of the hearing officer's proposed decision, but will not entertain arguments on Otter Creek's June 11th filing. Comments from the parties in all those proceedings are yet to be filed. The deadline for them has not yet passed. We have allocated an hour for today's argument. Otter Creek Solar, you have 30 minutes total, including any time you reserve for response. DPS, you have 30 minutes to use as you see fit. Mr. Melone, do you wish to reserve any of your time for rebuttal?
Yes, Mr. Chairman, I'd like to reserve 5 minutes.
Okay. All right, Mr. Melone, you've asked for the argument. You can go first.
Thank you, Mr. Chairman. Good morning to the other commissioners. So I won't argue this point, but I just wanted to note, like you did as an initial matter, that Otter Creek had filed that motion to resolve. It's our attempt to find common ground with the department and the commission, try to move these projects forward in a manner that benefits the people of the state of Vermont. We already have the modules in storage in Connecticut, so if we were able to resolve the issues related to this particular project, we'd be able to start construction once we can order all the other equipment. The other initial observation I'd like to make is that the town of Rutland, as you may have seen, did consider these projects again, including one of those other, or the project that's in one of the other dockets, Otter Creek 3. They viewed the amendment to the Otter Creek 1 project as just that, an amendment, that it would be the same project, not a new project, and that they would continue to view it as such, and they also voted to support the Otter Creek 3 project, both the Select Board and the Planning Board.
Mr. Melone, just to be clear, the information you just provided us about the town of Rutland, that is not a record in front of the commission. Is that correct?
I don't. They filed that in a number of dockets. I don't know if they filed it in this docket. They did file, I think, 2 days ago, a letter. Well, I guess they had filed a letter providing some comments maybe a month and a half ago, the end of April. Then they filed a letter 2 days ago indicating that they were going to support the Otter Creek 3 project, while at the same time they were not going to retroactively waive the 45-day notice for the Otter Creek 3 project.
My only question is are these filings that they made, are they items that you are seeking to have introduced into evidence in this proceeding? Do you want them to be part of this record?
I would say yes, we would. They support the notion, at least in the town's view, that they view that the project, the 2.2 megawatt project for Otter Creek 1, as simply an amendment, not a complete redo or a new project.
All right. Well, Mr. Melone, I'll treat this oral statement as a request on your part to introduce the filings that the town of Rutland has made. And by the way, is it the town or the city that has made it?
The town, select board, and the planning board jointly.
All right. I'll treat those as a request today to have them included in the record and provide the department until next Monday with an opportunity to comment on it. And Commissioner Hoffman?
Well, I do have a question. Have you filed these in EPUC in this case, the pieces of paper? It's one thing for us to say we'll consider it a motion, but I'm not sure what we're considering to be the evidence you want admitted. Have you put those into the record in EPUC?
No, Commissioner. With your permission, we would do that today.
Okay. If you'll do that today, Mr. Burke, is Monday too soon for the department to take a position on whether they should or should not be added to the record in this case?
No, that's fine. And Mr. Chairman and Ms. Hoffman, to your response, I'm looking at EPUC right now, and none of the comments from the town of Rutland are in EPUC for this particular case. I think it would be helpful to know specifically which documents Mr. Melone would like to have admitted into the record for this case. So seeing a list would be helpful. I have seen all the documents. I'm aware of them and will be prepared to respond by Monday. So thank you.
Good. Okay. All right, Mr. Melone, thank you very much. Please proceed.
So the first basis that we raise in this case for the relief that we are seeking is that the 2.2 megawatt project is not a new project. It's an amended project from the original application which we filed back in, I forget now, 2016. And at that time, for the 4.99 megawatt project, in the discussions that went on with the department and the back and forth testimony related to the benefits that would be received by the state of Vermont for a 4.9 megawatt project, one of the issues that arose out of that is we said that obviously we would, if we get a standard offer contract for a 2.2 megawatt version of the project, we would reduce the size of the project and request an amendment to reduce the size of the project. That's what transpired. Initially we tried to get a 4.9 megawatt PPA through PURPA by approaching Green Mountain Power and DEPI, but since the standard offer presented itself, there was no reason to pursue that, which obviously would have involved a longer time frame. So what we had planned to do, like we said in the testimony in docket 8797, is to just reduce the project size. Yep.
Commissioner Hoffman?
Thank you, Chair. Mr. Melone, isn't it true, though, that some of the characteristics of the site, when you had the 4.9, you actually did some work on them? My understanding is there's been some cutting. So the site is somewhat different than when you actually got your 4.9 megawatt project.
The site is cleared now, but that was something that was part of the plan that was approved. I think the fact that we have cleared the site, which we were permitted to do under the CPGs, that doesn't change the fact that we're going to still build that project, and we could build it as we originally proposed in the related case to this in a more compact manner, or we could build it so it's a larger footprint, basically fitting in the pretty much the same footprint as was approved in docket 8797. So I guess my thought is that if someone is going to file an amendment, whether it be to reduce the size of the project or to change equipment or do something else, they could do that at the beginning, in the middle, or near the end, but before they do it. But as long as they've done the clearing or whatever else that they're allowed to do, it seems to me that shouldn't trigger an entire reevaluation. The way I read the rules, or the Commission's rules, is that you look at the change and you determine if it's a substantial change. And the way to determine that is if it has the potential for significant impact on Section 248 criteria. And I don't think the shrinking down of the AC size has a significant impact on Section 248 criteria.
Commissioner Cheney? You're still on mute.
Thank you. My question was answered in the course of the latter part of Mr. Malone's speaking. Thank you.
All right, thank you. Mr. Melone, I do have a question. You've mentioned the fact that it had always been your plan that while you were getting the CPG for a 4.9 megawatt project, if you got a standard offer for a 2.2 megawatt project, you would then amend or modify your CPG for the 4.9 project. And according to the record evidence, you got the standard offer contract for this project effective August the 27th of 2018. When did you apply for the amendment to the 4.9 CPG to effectuate what you claim was your intention from the beginning, namely to have the project be a 2.2 megawatt standard offer project if you got a contract?
I don't have the exact date, but I think it was sometime early in 2019. It's I would say it was early 2019 when we filed the amendment.
I'm sorry, but according to the...
I'm sorry, 2020.
Yes,
sorry.
Okay.
Yeah.
All right, so,
it was early this year. That's right. Early this year.
All right, so well over a year passed after you got the standard offer contract for the 2.2 before you moved ahead with what you say was your intention from the outset, namely to amend the 4.9 CPG project to make it a 2.2 standard offer. I just want to make sure I understand that. Is that correct?
That's correct, Mr. Chairman.
Okay. All right. Go ahead. Thank you.
So that's a good point. The answer, the reason why we waited is we were in the process of clearing the site, as the commission knows. But then I'm not going to debate the merits of the order, but in June 2019, the commission issued an order as part of an investigation over the clearing. It basically shut down everything in terms of construction development. The reason why it shut it down was because in that order, the commission threatened the possibility of revoking the standard offer contracts. So at that point, we had to stop and get financing. And also at that point, we could have amended or filed the amendment to the CPG to reduce it to 2.2 megawatts. But at that point, we didn't even know, until the commission resolved the other dockets, whether we in fact would have a standard offer contract anymore at the 2.2. So we waited until I think sometime in January, when the deadline was coming out for Otter Creek 3, in the hope that the commission had resolved the investigation and that we would have known what PPAs we still have or would have to continue to fight for. But since we were facing that deadline, we had to make some choice, and that's what we did. But it would have been done earlier, but for the fact that we weren't sure at that point whether we were going to have the PPA to amend the project to align with. That basically occurred in June. So that's the reason why it was such a delay.
All right, Mr. Melone, you said just now you would have done it earlier. In fact, you had the standard offer contract in August of 2018. The commission didn't take any action that would have, in your view, cast a cloud on the validity of that standard offer contract until June of 2019. So why didn't you do something with regard to the amendment or seeking an amendment to the 4.9 project in all those months between August of 2018 and June of 2019?
Well, in the worst case scenario, we would have had a year. I mean, in my view, we had a longer period of time than that, because in my view, we had a CPG already. But even if you assume for the moment that we had to file the amendment by August 22nd, 2019, we had until then. I had viewed it as a something that really wouldn't have been as controversial as it turns out to be, because from my point of view, we had disclosed it to the commission as part of the approved project, and then when we would actually implement that plan, we would think it would be like a fairly easy change. But we didn't have to face that because we still had time, another 2 months, when the commission's order came out, casting the cloud on whether we had the standard offer contract at all. So,
thank you. Go ahead.
Yeah. So, as we argued in the papers, in accordance with at least the way we view the rule and commission precedent, that on the filings of CPGs, that the amendment or that we met the milestone because we had filed the initial application, and that even if the amendment needed to be filed by August 2019, like I explained, we think there was good cause for not doing it after the June order, and that we just hope that we can resolve at least this project with the commission and the department and move forward.
Mr. Melone, the things that you feel happened starting in June of 2019 that cast this cloud, had any of those things gone away when you finally filed a request for an amendment of the 4.9 project at the end of January of 2020?
No, they haven't. So, yeah, so like I said, at that point, we felt like we had to make some decision because we had to file the Otter Creek 3 application for a CPG. So that's why we filed those then, and hope that pretty soon after the commission would have lifted the cloud on the CPGs and the standard offer projects, or the standard offer contracts. But like I've said in some other filings, the language of the orders, even in that docket, have still not yet affirmatively said that.
And let me understand. First of all, correct me if I'm mistaken. Otter Creek 3 is, if you will, the other half of the 4.9 project site, correct?
Yes, that's the way we envisioned it.
Okay. And you felt that in order to get Otter Creek 3 standard offer contract CPG approved, in order to get that project moving ahead, you had to amend the 4.9 project so that there would, in effect, be room to put the Otter Creek 3, correct?
Correct. I don't think we could have had, well, I think for us to have filed the Otter Creek 3 application, by the deadline, we would have had to have on file an amendment request that cleared the way for the land. That's it.
But you did not apparently think that was the case for Otter Creek 2. You didn't seek the amendment before you moved ahead with the Otter Creek 2 project.
Amendment
to the 4.9 project. The same problem that Otter Creek 3, if you will, the logistics problem that Otter Creek 3 created for you, which is you were trying to put it on a site that already had a CPG for a different project. That same problem existed with regard to Otter Creek 1. Otter Creek 1 was also proposed to be sited on a site that had a CPG for a 4.9 project. I'm trying to understand why you wouldn't have felt the need to file the request to amend the 4.9 project as soon as you knew you had Otter Creek 2, Otter Creek 1 as a standard offer contract.
You mean, why wouldn't have we filed the amendment to Otter Creek 1 once we knew we had a standard offer contract for Otter Creek 3? Is that?
No. Why wouldn't you have moved to amend the 4.9 project CPG as soon as you knew you had an Otter Creek 2, an Otter Creek 1 standard offer contract? You just said that you realized for the standard offer for Otter Creek 3, you needed to clear the way by getting an amendment to the 4.9 CPG.
Right.
Why wasn't that equally relevant for you once you got a standard offer contract for Otter Creek 1? Why didn't that trigger you, instead of using the full year or 10 months to seek an amendment to the 4.9, why didn't you seek an amendment to the 4.9 shortly after you got awarded the standard offer for Otter Creek 1? I'm not understanding the logic of why January 30th suddenly became the date on which you filed an amendment to the 4.9 project that would justify your having not filed that amendment shortly after you got the standard offer contract for Otter Creek 1?
I'm trying to think of if there was a deadline. I thought there was a deadline around the time that we filed these, and it was may have just been Otter Creek 2, or I thought we had a deadline to file the Otter Creek 3 CPG by a certain, or the CPG application by a certain date, and we did everything around the same time. I mean, one of so I thought we had at least a certain amount of time to plan the best way to try to approach the 3 projects. And it wasn't clear to me under Section 248 or the Commission rules whether or not, because I don't think anybody ever asked this, is whether you could just split the projects. Whether an amendment to Otter Creek 1 could just be a request to split it into 2. We couldn't find any precedent on that. Couldn't find anything that would say that wouldn't be the case. We have done that in other states, like in Connecticut, where we had a project or a bigger project, and the state just let us split it into 2 without going through the whole process again. But at the end, we just decided that since the deadline was coming up to make these filings in 2019, that we would have to go through the process of amending Otter Creek 1 and submitting what we had hoped would be an easy way to effectively split the projects by filing a 248J. I mean, we didn't think that it would be, controversial to put solar in the same place that solar had already been approved, when really all you were doing was building a separate interconnection and a separate way to access the project. I mean, so I mean, we could have done it earlier. I didn't think we were required to do it earlier based on the reading of the contract. But by the time the cloud hadn't been lifted in early 2020 on all the projects, we're coming up on the standard offer contract deadline for Otter Creek 2. Then we just needed to try to proceed with the project on some basis.
Okay. Mr. Melone, your time is up. If you want to reserve the 5 minutes for rebuttal, or you can use some of that and not have as much for rebuttal, what would you prefer?
I'll reserve the time for rebuttal, Mr. Chair.
Okay. Mr. Burke?
Yeah. Before I get started, I believe Commissioner Hoffman had a question. I don't intend to use much time, so if she wants to ask her question.
Okay. I'm sorry. Thank you for seeing that.
Thank you very much.
My apologies. Chairman Burke, saw you there.
Thank you very much, Mr. Burke. I was just wondering, Ms. Melone, you actually said after looking at the contract, you didn't think you needed to do that. But my understanding of reading the contract is you did have a date. You can argue about whether an amendment to the 4.9, et cetera, but under the contract, there is a date you had to file for your project. So I'm not sure where you're reading in the contract. I guess I would ask you to point that out to me where you thought you had more time.
Yeah, Commissioner, the way I read that is that that the application that we originally filed should be sufficient to satisfy that contractual provision. and that when we file an amendment, it's really an amendment to an application that predates the deadline for that milestone. So that's the view that I took when I read the contract, that we effectively had a CPG. Not only had we applied for one, we had one. All we needed to do was amend it, like we said we would in the original docket. And to be honest, I didn't think it would be such a controversial issue to do exactly what we said we would do.
Thank you.
Thank you, Mr. Melone. Now, Mr. Burke, thanks for spotting that.
Thank you, Mr. Chairman. Good afternoon, or good morning still, everyone. I don't have a set presentation to make this morning. I really would like to make my time available to answer any questions that the commission members or staff may have about the department's position in this case, any filings that we've made. But I do want to make clear, although Mr. Cotter's proposal for decision did not adopt the department's recommendation in this case, we don't see any error in the proposal for decision that he put together. We don't see any flaws in that, and we think, if it were to proceed under full adoption by the commission, it would survive any judicial or appellate scrutiny going forward.
Okay, and Mr. Burke, I do have one question for you. The department, in its filing on March the 27th, at page 3, said that you had recommended that while there had been a violation of the standard offer contract, that the commission should nonetheless allow an extension of the filing deadline for a CPG for Otter Creek number 1, the standard offer contract, Otter Creek 1, until June 1. And that if that weren't done, then it was the position of the department that the standard offer contract would be null and void. As you know, no application for the CPG for Otter Creek 1, the standard offer contract, has been filed. This is the department's position now that the standard offer contract is null and void.
So, well, the standard offer contract will be null and void as a matter of law unless you, the commission, actually extends the deadline. So the deadline was, I believe, last August, if I'm not mistaken. And maybe I can take a step back and help frame why we put that recommendation the way we did, and that might answer your question a little bit better. The thought process was that if Otter Creek Solar acted promptly and quickly to put together application materials for a full Section 248 Certificate of Public Good by the beginning of the summer, it would have been highly unlikely, but potentially possible, that they could still reach the commissioning milestone, which is set for, I believe, August 27th, if I'm not mistaken. And even if we were unable to do a full 248 review over the summer months, there would have still been a possibility to complete the project within this upcoming construction season. So we were looking at a difference between the Certificate of Public Good application filing milestone and the commissioning milestone, and recognizing that there was still a possibility to meet or come close to the initial commissioning milestone, even though they had missed the initial application filing milestone. And consistent with what we've heard from Mr. Melone today, we were concerned about potentially setting bad precedent for future cases, although it may be unlikely to have very similar facts as this, where an applicant makes a good faith but wrong legal assumption about whether or not they needed to make another regulatory filing, whether it be an amendment to an existing CPG or a full-fledged new 248 petition, when facts on the ground change for a petition. We did think that their legal position, though flawed, was made with good faith. So that's where the department got to the recommendation it did in this case. Now to answer sort of the nut of your initial question, we've now passed that initial June 1st deadline. And I think if Otter Creek Solar were to proceed, they would, I'm not sure where they stand in terms of doing any pre-application notices to any statutory parties, but it would seem like it would be next to impossible to get a full 248 process started really till the end of the summer at this point. So that would be a concern for us in terms of the delay and how that related to our initial recommendation in this case, Mr. Chairman. I'm sorry, you're muted, Mr. Chairman. You're muted, Mr. Chairman.
Yes, thank you. Thank you, Mr. Burke. I appreciated all that additional information, but I'm not sure you quite answered my question. As I read what the department filed on the 27th of March,
Yep.
Your view was if the June 1 deadline was not met, then the standard offer contract was null and void, and that was the end of it. Is that now the department's position? I understand you said that you support the P4D, and that comes to that conclusion, but I just want to be clear that the department believes that the commission should find that the standard offer contract is null and void and that its deadline should not be extended.
So I do have a little qualifier. I pulled up the section. I did have a parenthetical there saying either that date or any other date set by the commission to extend the milestone. So there was a qualifier there. So our thought process was to give a very narrow extension of the time to get the ball rolling on a 248 review as quickly as possible. So June 1st was the date we came up with because we thought that was a reasonable, though tight, amount of time to get an application material together, but we recognized the commission, if it went along the approach the department initially recommended, that could have proposed an alternate date, June 15th, July 1st. So you would have the authority under section 8005A to amend the contract and set a milestone, deadline, date, and new one. And whether or not they adhere to that deadline would be the determining factor as to whether or not the contract is rendered moot. So that sentence was couched within the context of an assumption. I think I tried to make that clear in that filing that, yes, department, we accept this recommendation. We'll set June 1st, but there will be no further extensions beyond that. Or you could have set an alternate date.
Okay.
Does that help answer your question?
Yes, thank you, Mr. Burke. I had one other question for you. I noticed it again in that filing on the 27th that the department spoke of the public interest value of having a 2.2 megawatt solar project and how it would help meet a variety of policy goals set both by the legislature, statute, and by the commission and the department. Is it correct that if the project that was originally approved for this site, the 4.9 megawatt project, were in fact built and a contract was obtained on the open market for that would also be in the public interest and would actually be more than twice as big as this 2.2 megawatt project?
Well, I think the commission's already determined that a market-based contract would be in the public good. So that is a matter of final conclusion from the prior CPG docket. I think your question might go to, is there a difference between having a 4.9 megawatt wholesale market contract versus a 2.2 megawatt standard offer rate? Is that kind of what you're asking? Is there a balancing factor there? Yeah, and I think that would, the answer to that is it would depend. It would depend if they're required to seek a future standard offer contract. It would depend on where the clearing price for standard offer contracts is in the future, and it would depend on what Mr. Melone is able to negotiate in terms of the PPA and the wholesale. Presumably, it would be lower on a wholesale rate. I think that has historically been how PPAs have played out in Vermont relative to the standard offer price, but that would be making an assumption based on experience at that point.
Okay, thank you, Mr. Burke. Commissioner Hoffman?
Thank you. Mr. Burke, in terms of public policy, though, would you agree that it is important that the contracts be adhered to? Because it is a competitive bidding process, there are people who want these contracts waiting in the wings, so to speak. And let's say it's somebody else in this situation, and Mr. Melone is the one waiting for the next iteration of the contract bidding. Is there? I'm sorry, I'm being very inarticulate, but it seems to me there is a public policy concern around not adhering pretty strictly to the contract that is signed by one of the bidders who wins one of these.
Yes, and I think, Commissioner Hoffman, maybe I can rephrase your question back to you. Are you speaking somewhat to how the standard offer bidding process is set up to ensure that contracts or proposals that are coming forward for contracts are structured so that these projects are real projects, they're ready to go, and that they're not hypothetical or theoretical projects? Is that sort of... Yeah.
Yes, and that then the milestones are adhered to.
Yeah, and I think if the commission is lax or will consistently always grant extensions on milestone or granting requests to extend milestones, then yes, there's a public policy concern that you're undercutting that policy that we've put in the separate bidding process to ensure that projects are, fully mature before they're coming into the standard offer contract. And I think that's an issue that Mr. Melone has raised in several appeals on some of the standard offer bids that have come out. So yeah, there certainly is a public policy concern on being too forgiving, for lack of a better word, and allowing some of these milestone extensions to go forward.
You're on mute.
Yeah, Commissioner Cheney, sorry.
So, Mr. Burke, in addition to the public policy goal of having fully fleshed out projects, real projects, not hypothetical projects, would you agree that there's also the goal of fairness, essentially, so that such a project is not taking up space, given that there's a cap, both annual cap and cumulative cap? So unreal, let's put it that way, or not fully fleshed out projects shouldn't take up space from real ones, given that this is not an open-ended program?
Yes, we certainly would.
Commissioner Hoffman, any further questions for Mr. Burke?
Oh, I have none. Thank you very much, Mr. Burke.
Mr. Cheney?
My neighbor has some goats that are right outside my window, so I apologize if that's been making any noise.
No, but we would like cheese. Commissioner Cheney, any questions?
I have no further questions.
Mr. Burke, do you have anything else to add?
No, that is all. Thank you, Mr. Chairman.
Okay. Mr. Melone, you've got 5 more minutes. You can proceed.
Thank you, Mr. Chairman. I'll just quickly address the 2 points that were just made. The facts of this case are far different from a project that wasn't real. I mean, the project has a CPG. We told the commission we would file an amendment. So it's a real project. It's not taking up space. Like I said, we have the modules. We had them ready to go even back last year, but the June order stopped everything. So I don't think that the facts of this case support the general thought that a project that's not real shouldn't take up space in the queue. This project was real. We spent a lot of money getting the CPG. And what we thought would be an easy thing to amend it to a smaller project, like we told the commission, turned out to not be an easy thing. And on the first point about what's in the public interest, there are no there's no way to get a contract on the open market to build a solar project. I mean, you can't build a project under Rule 4.100. No projects have ever been built, to my knowledge, no solar projects have ever been built under 4.100. Green Mountain Power has no interest in signing a PPA because they build their own projects and rate base them. And you can't build a solar project without a long-term PPA. So, sure, Green Mountain Power had agreed to sign a PURPA contract when we initially proposed one for a 4.9 megawatt project at the rate that they got approved by the commission at that same time. We could have built the project, because that's all we were asking for at that time. Green Mountain Power had all their various 4.9 megawatt projects before the commission for approval. All we asked was for the same rate, but they wouldn't give us the same rate. So our project, you need a PPA. The standard offer PPA is such a PPA. Without that PPA, there are no alternative ways to get PPAs in Vermont from a realistic perspective. So there is no value that's going to be realized by the larger project in terms of the public interest. Because right now, without a new case to try to get a PURPA contract at a decent rate, I just can't be done. So, like the department says, I think this is a real project that can be built. I'm not sure if it could be built this year at this point, but if the cases were resolved quickly, certainly possible, since we have the modules in storage. Unless the Commission has any other questions, I thank the Commission for its time.
Commissioner Hoffman, any more questions for Mr. Melone?
I have no further questions. Thank you very much, Mr. Melone.
Commissioner Cheney, any further questions for Mr. Melone?
No, thank you, Mr. Melone.
Thank you, Commissioner Cheney.
Mr. Melone, Mr. Burke, thank you both. We will take this under advisement. Ms. Sears, thank you for your presence and, as always, your work. We appreciate it. This hearing is concluded.